Constitutional Bunge Mashinani, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the lawful and official gazetted premises of County Assembly and without lawful appointment. 7. Further, the Governor made public pronouncements declaring Enoch Ogori Okero and Silvanus Ndemo Nyamira as the legitimate Speaker and Clerk, respectively, while aware that Enoch Ogori Okero was duly impeached. 8. The Governor's actions to formally engage, endorse, and support unlawful, illegal, and unconstitutional Bunge Mashinani directly undermined the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and County Governments Act 2012, thereby constituting a gross violation of the rule of law and the principle of separation of powers. Allegation 2, gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on the democratic principles and separation of powers, whereas Article 185(1) of the Constitution of Kenya 2010 states that the legislative authority of a county is vested in and exercised by its county assembly, whereas Article 224 of the Constitution of Kenya 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament, whereas Section 21, subsection 1 of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor, whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the county assembly for consideration and approval. 1. The governor on 26 November 2024 assented to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira, in total defiance to the constitutional principle of separation of powers. 2. The Nyamira County Supplementary Appropriation Bill 2024 is not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 26 November 2024. 3. The Nyamira County Supplementary Appropriation Act 2024, as assented by the Governor, significantly altered the priorities and development programs in the original approved budget. 4. This conduct constitutes a gross violation of Articles 175A, 181(1), and 224 of the Constitution of Kenya 2010, Section 130 of the Public Finance Management Act 2012, Section 21(1) of the County Governments Act 2012, and Order Number 137(1) of the County Assembly of Nyamira Standing Orders, and the due process of the law, which requires that the county budget be approved by the County Assembly. 5. The same undermined the representation and oversight role of the County Assembly. The supplementary budget was assented to, devoid of participation of the people and or their representatives. Allegation number 3. Gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing Dr. Peris Nyaboke Oroko, alias Peris Mongare, to the County Executive Committee CEC without the approval of the County Assembly. Whereas Article 179, 2B of the Constitution of Kenya 2010 provides that the County Executive Committee shall consist of members appointed by the County Governor with the approval of the County Assembly from among persons who are not members of the County Assembly. Whereas Article 259 of the Constitution emphasizes the interpretation of the Constitution, which includes the respect for judicial announcements. Further, whereas Section 30D of the County Governments Act 2012 requires the Governor to appoint, with approval of the County Assembly, members of the County Executive Committee. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. His Excellency Amos Nyaribo appointed Dr. Peres Nyamboke Oroko to the County Executive Committee without the approval of the County Assembly of Nyamira, in total disregard of the due process of the law. 2. In response to an inquiry by the County Assembly, the County Executive Committee member for Public Service Management maintained that the Peres Nyamboke Oroko is duly appointed. 3. Failure to submit the name of Peres Nyamboke Oroko for vetting and approval by the County Assembly of Nyamira constitutes gross violation of Articles 179 2B and 259 of the Constitution of Kenya 2010 and Section 30D of the County Government Act 2012. 4. The Governor has to date proceeded to retain Dr. Peres Nyamboke Oroko and supervised her integration into the payroll system since June 21, 2025, and authorized the payment of her salary and allowances despite clear judicial and senatorial pronouncements declaring all actions of Bunge Mashinani as illegal, null, and void. 5. The Governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 6. This action presently bypassed the County Assembly, constituting a gross violation of the Constitution and statutory provisions governing appointments. Allegation number 4. Gross violation of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, and Public Appointments County Assemblies Approval Act 2017 by appointing Nyamira and Keroka Municipalities Board members without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on national values and principles of governance requires that the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Section 14, subsection 1 of the Urban Areas and Cities Act of 2011, as amended in 2019, requires that a board of a municipality shall consist of 9 members appointed by the county governor with approval of the county assembly. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. His Excellency Amos Nyaribo, by the Gazette Notice number 1965 of 2025, dated 30th February 2025, appointed members to the boards of Keroka and Nyamira municipalities without the approval of the County Assembly of Nyamira, in direct defiance of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, as amended 2019, and the Public Appointments County Assemblies Approval Act 2017. 2. The approval of the members to the 2 board members was not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 19th November 2024. 3. The Governor has to date retained the said board members in defiance of clear judicial and senatorial pronouncements. 4. This constitutes a blatant disregard for the rule of law and contempt for legitimate authority. Allegation number 5. Gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 by appointing the selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on the national values and the principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73 and 74 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 232, subsection 1 of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. The governor appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. 2. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 3. The selection panel proceeded to invite, shortlist, and conduct interviews for the applicants for the positions of chairperson, secretary, and members of Nyamira County Public Service Board, in total defiance of clear judicial and senatorial pronouncements. 4. These actions are contrary to the constitutional principles and undermine public service integrity. Allegation number 6. Gross violation of the Constitution of Kenya 2010, County Governments Act 2012 by failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Whereas Article 235 of the Constitution of Kenya 2010 provides that a county government is responsible for A, establishing and abolishing offices in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 58A(1) of the County Governments Act 2012 provides that whenever a vacancy arises in a county public service board, the governor shall nominate and, with approval of the county assembly, appoint members to a selection panel for the purpose of selecting suitable candidates for appointment as members of the County Public Service Board. And whereas Section 58A(7) provides that the governor shall, within 7 days of receipt of the names forwarded under subsection 6, nominate one person and at least 3, but not more than 5 others for appointment as chairperson and members of the County Public Service Board, respectively, and forward the names to the County Assembly for approval. 1. The Governor, His Excellency Amos Nyaribo, has to date failed to nominate for vetting, approval, and appointment of the chairperson, secretary, and members of the Nyamira County Public Service, despite vacancies arising in the Nyamira County Public Service Board as from 5th of July 2025. 2, the absence of a county public service board has created a lacuna in management of the human resource function of the county government of Nyamira. In the obtaining circumstances, the provisions of Article 235 of the Constitution of Kenya 2010 cannot be realized in the Nyamira County Public Service. 3, additionally, this has eroded confidence and public trust in the leadership of Governor Amos Nyaribo. Allegation number 7, gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 by failing to submit annual reports and deliver an annual State of County address to the County Assembly for 2 consecutive years. Article 183(3) of the Constitution of Kenya 2010 provides that the County Executive Committee shall provide the County Assembly with full and regular reports on matters relating to the county. And Section 32J and K of the County Government Act 2012 mandates the Governor to J, I quote, under J, submit to the County Assembly an annual report on the implementation status of the county policies and plans. K, deliver annual State of the County address containing such matters as may be specified in county legislation. 1, the Governor has failed to submit annual reports and deliver annual State of the County address to the County Assembly of Nyamira for the past 2 consecutive years, 2023-2024 and 2024-2025 as required by law. 2, this failure constitutes a gross violation of constitutional and statutory provisions demonstrating a blatant disregard for transparency, accountability, and the oversight role of the County Assembly. It further denies residents of Nyamira County an opportunity to hold their governor accountable. 3, the Governor's consistent and prolonged failure to deliver the constitutionally required State of the County address demonstrates a deliberate act to evade accountability to the County Assembly and the people, thereby constituting gross violation of constitutional and statutory mandates. Allegation number 8, gross violation of the Constitution of Kenya 2010 by failing to appoint and obey court orders regarding the appointment of Cliff Ogwora to the County Executive Committee. Whereas Article 159(1) of the Constitution of Kenya 2010 provides for the exercise of judicial authority, whereas Section 14(1)(a) of the Contempt of Court Act 2016 provides that contempt of court includes civil contempt, which means willful disobedience of any judgment, decree, direction, order, or other process of a court, or willful breach of an undertaking given to a court. Whereas the Employment and the Labor Relations Court at Kisumu in ELRC JR number 10 of 2021 ordered the Governor to appoint and pay salaries to Mr. Cliff Ogwora. 1, His Excellency Amos Nyaribo failed to appoint Mr. Cliff Ogwora nominee for member of the County Executive Committee, despite the fact that the nomination was cleared by law for appointment. 2, the Governor's disobedience of the High Court order directing him to appoint Mr. Cliff Ogwora resulted into the loss of a discreto sum of Kenya shilling 4,417,875. 3, the actions of the Governor, including delayed settlement, resulted into loss of public funds amounting to Kenya shilling 6,922,203.75, being the discreto sum plus costs, interest, and other incidentals. Ground 2, abuse of office. Whereas Article 10 of the Constitution on national values and principles of governance require the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Articles 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability, among others. Whereas Article 232, 1 of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. His Excellency Amos K. Nyaribo abused his office in the management and administration of county affairs through the following acts as particularized below. The particulars of this ground are as follows. Allegation 1, abuse of office by improper use of his authority in recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution...
Clerk, just give me a minute. His Excellency, the Governor, we still have a long way to go reading your charges. In the event that you're tired, you may take a seat. We don't want you to collapse while these charges are being read. Proceed, Clerk.
Thank you.
Allegation 1, abuse of office by improper use of his authority in recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution on national values and principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 201A, D, and E of the Constitution of Kenya 2010 states as follows. A, there shall be openness and accountability, including public participation in financial matters. D, public money shall be used in a prudent and responsible way. E, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency and fair competition and merit. And whereas Section 107(2)(c) of the Public Finance Management Act 2012, PFM Act, require that the county government's expenditure on wages and benefits for its public officers shall not exceed a percentage of the county government's total revenue as prescribed by the county executive member for finance in regulations and approved by the county assembly. Whereas Section 8(1)(c) of the County Governments Act 2012, which provides for the role of the county assembly, including approve the budget and expenditure of the county government in accordance with Article 207 of the Constitution and the legislation contemplated in Article 2202 of the Constitution, guided by Articles 201 and 203 of the Constitution. 1. His Excellency Amos Kimwomi Nyaribo presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Minutes MIN number 04/02/2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with full knowledge that there was no budgetary provision. In the said response to issue number 4 in the question, the Governor alleged that in lieu of the budget, the recruitment was based on the savings made from various separations, which included but not limited to recruitment and resignations. 2, despite a resolution of a county assembly to freeze new employments on account of lack of budgetary provision for any recruitment dated 1st July 2021, which freezing was never vacated by a resolution of the county assembly. 3, further, in spite of an advisory from the Secretary of the County Public Service Board dated 29 July 2021 to the County Executive to put the impurged recruitment in abeyance, considering that there is no budgetary provision for any new recruitment. 4, His Excellency Amos Nyaribo has to date proceeded with a recruitment frenzy that has ballooned the county wage bill, making it unsustainable, irresponsible, and imprudent, contrary to the provisions of the Public Finance Management Act 2012. 5, the Governor's influence over the recruitment of hundreds of staff without budget, in defiance of EACC advisory and County Assembly resolutions for political expediency and personal gain, constitutes a clear abuse of office aimed at fiscal plunder and violation of constitutional values and principles of governance. 6, since the year 2021, when His Excellency Amos Nyaribo assumed office as governor, he has influenced the recruitment of staff without budgetary provision and approval of the County Assembly of Nyamira, and particularly A, in February to April 2021, there was a recruitment of 49 officers. B, the recruitment of Deputy County Secretary, County Attorney, support staff, ward and county and sub-county administrators. C, on March 9, 2023, the County Public Service Board advertised for 358 vacancies. Despite lack of approved budget for recruitment, a recruitment freeze by the County Assembly, and disregard for EACC advisories. The recruitment, projected to add Kenyan shilling 325 million annually, proceeded without any budgetary allocation or approval. D, outstanding arrears to the tune of Kenyan shillings 60 million arising from unpaid salaries to healthcare workers for a period of 7 months. Allegation number 2, abuse of office by influencing the appointment of Godfrey Kiriago and Elmelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management, Payroll Management, respectively. Whereas Article 179 of the Constitution designates the county governor as the chief executive of the county, whereas Article 232(1)(g) of the Constitution of Kenya 2010 mandates fair competition and merit as the basis for appointments and right to equality and freedom from discrimination, whereas Articles 75, 76, and 77 of the Constitution govern the conduct and financial probity of state officers, whereas Section 30 of the County Government Act 2012 provides for the functions of the governor, whereas Section 45 of the Anti-Corruption and Economic Crimes Act of 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In a letter dated 18th January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Amos Nyaribo, to the County Public Service Board, seeking the secondment of 2 cherry-picked officers, Godfrey Kiriago Nyangao and Elmelda Nyaberi, to the positions of Director Human Resource and Payroll Management, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said offices ought to be vacant and that the process must follow the laid down procedures and legal provisions. 2, the governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and caused irregular integration into the county payroll. 3, by initiating the non-competitive appointment and retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of his office, leading to a direct and quantifiable loss of public funds, since the 2 officers were hitherto substantively occupied. 4, the governor further influenced the appointment of Godfrey Kiriago to the position of Deputy County Secretary and influenced the renewal of Mrs. Elmelda Nyaberi's contract post her retirement date. Allegation number 3, abuse of office through personal enrichment from receipt of irregular salary arrears of Kenya shilling 5,649,706. Whereas Article 201A, D, and E of the Constitution of Kenya state as follows: B, there shall be openness and accountability, including public participation in financial matters. F, public money shall be used in a prudent and responsible way. G, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission, SRC, to set and regularly review the remuneration and benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, PFM Act, requires public funds to be used in accordance with the law and for the purpose of which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In September 2021, through the facilitation of the 2 cherry-picked officers, Mr. Godfrey Kiriago, Director Human Resource, and Elmelda Nyaberi, Payroll Manager, the governor conferred upon himself an irregular salary payment christened as arrears amounting to Kenya shilling 5,649,706. It is apparent that there was no outstanding arrears due to the governor since his assumption to office, and neither was he owed any arrears as deputy governor. 2, the governor's self-authorized receipt of Kenya shilling 5,649,706 in salary arrears outside the Salaries and Remuneration Commission guidelines is a clear act of personal enrichment, abuse of office, and a direct violation of PFM Act. 3, the governor has publicly confessed that he received the above irregular payment. The people of Nyamira lost services and development programs to the tune of Kenya shillings 5.6 million on account of his abuse of office and or his actions. Number 4, the governor has formed a habit of conferring upon himself irregular benefits going by other incidences. For instance, in the year 2019, the governor caused to be paid a retrospective compensation of Kenya shilling 13 million in allowances for housing, bracket, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF, all outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment, abuse of office, and direct violation of PFM Act. 5. This direct financial benefit to the governor constitutes a direct loss of public funds and demonstrates a clear case of personal enrichment through corrupt practices and abuse of office. Allegation number 4, abuse of office through systemic payroll fraud and syndicate, the Kenya shilling 32 million payroll heist. 1. Besides an irregular receipt of Kenya shilling 5,649,706 has already established, in particular, allegation 2.3, the governor presided over a well-orchestrated syndicate of payroll fraud, which led to massive loss of public funds through huge, irregular, and unexplained salaries and specified and special allowances paid to Mrs. Rose Bosibori Guto, an ECD teacher, bracket Kenya shillings 25,018,852. Ms. Gladys Mora Nyambane, an ECDE teacher, bracket Kenya shilling 1,100,467. And Mr. Isaac Kerongo Bonchiri, an ECD teacher, Kenya shilling 700.